Deputy Naughten.
Yeah, just Minister, listen, thanks for your commentary in relation to that. Look, I'm quite willing to accept whatever wording that you would bring forward. I accept that I'm not a parliamentary draftsman by any manner or means, so I'm quite willing once the thrust of the amendment is accepted. And I do accept, Minister, that there is no impediment there. The difficulty is in 99.9% of cases there won't be an issue, but all you need is one difficult member of staff within the HSE, and all of a sudden a vulnerable person could potentially be exploited, and none of us want to see this happen. So it's a belt and braces approach, and I thank you for your commentary, and I would draw the amendment on that basis.
Okay,
thank you very much. That's much appreciated. And Cathaoirleach, if I could just say, Deputy Durkin raised another issue in relation to timeframes. That will be dealt with later on in another amendment that has been tabled, and we can discuss it then. So thank you for your cooperation, Deputy Naughten.
So you might ask then, does Deputy Naughten want to withdraw his amendment?
You've withdrawn your amendment then, Deputy Naughten, yeah, great. Okay, that the sections 4 stand part of the bill. Is that agreed?
Just hold on, Chair, for us. Yeah, sorry, that's okay, yeah.
Yep. Moving on then.
They have to agree.
Is that agreed?
Is that agreed? Agreed.
That section 4 stand part of the bill. Is that agreed?
Agreed.
Yeah, okay. Section 5. Again,
yeah,
it's ruled out of order, Denis.
Yeah, no, I know that, Chair, and I want to speak to the section.
Yep.
Yeah, so just to the section in relation to my amendment, which has been ruled out of order, Minister, because there is a potential charge on the state. And I listened quite intently to what you said at second stage, and that you didn't want to backdate it because it would create a precedent. It doesn't create a precedent. We have had numerous precedents in the past, particularly in relation to issues of compensation, where payments have been backdated. Even as late as last November, we had a statutory instrument being brought forward that backdated provisions to the beginning of October. So it's quite common in these cases. It is also the case, and there are many precedents there, that the government has brought in legislation that actually implemented the provisions from the date of the government decision. Now, the government decision was made 3 years ago in relation to addressing these particular anomalies within the Fair Deal scheme. There are only a handful of people, I believe, that would now be impacted by this particular provision. But in those instances, some of them have very substantial bills accruing against their family home, against their estate, for someone that went into a nursing home more than 3 years ago. And I believe that this issue does genuinely need to be addressed for those particular families. So absolutely the issue is addressed from here going forward, and anyone where the costs had accrued prior to the government decision 3 years ago, they don't have a legitimate claim in relation to this. However, the government took a decision 3 years ago, next month, to actually exempt after 3 years the family farm or the business. Now, it has taken 3 years, and I know this has been a tortuous process in bringing forward this piece of legislation. I accept that. But should individuals be penalised, be forced to sell the family farm, be forced to sell the family business because of the delay in implementing the government decision and in drafting this particular legislation? As I say, I suspect that we're talking about a relatively small number of families here, a small number of individuals, and I would plead with you to consider this again in advance of report stage of this particular bill.
Can I respond, Cathaoirleach?
You can, of course, yeah. Minister.
Thank you very much, and thank you, Deputy Naughten. The relief under this bill is not automatic and is contingent on the family successor being appointed. The family successor cannot be appointed until the amendment is enacted and commenced. So that's the big problem. The whole condition of this scheme to be met means that you have to have a successor in place. That's the whole premise on which this scheme is being enacted. But I just think it needs to be very clear so that everybody understands. For those who've already been in care more than 3 years prior to the bill being commenced, they will be advised to appoint a family successor quickly once the bill has been commenced. If they do so, they'll avail of the relief very quickly. So say, for example, a person has been in a nursing home for the past 2 years, and if they appoint a successor as soon as the bill is enacted, those 2 years will stand as time already served in the nursing home. We're trying to make it as workable as possible. So once the successor is appointed, any time after being spent in the nursing home will be included. So if a person has been there 2 years, they'll only have to get to a third year in order to avail of the cap on the scheme. So for those who enter care after the enactment of the bill, they will be advised to, as I said, to appoint a family successor soon after entering care. The logic of this section is to avoid a situation where an argument can be made that the relief should be backdated to a date prior to the amendment being commenced, specifically for persons who already have spent more than 3 years in care. So unfortunately, the reason why the Bills Office rejected this, there would be a cost on the state. But we are working very, very closely to make sure that any time served once the successor is appointed is recognised.
Yeah, look, Minister, look, we'll disagree in relation to this, and I'm not going to dwell on it, but I believe that it is unfair for, you've given an example of someone that is 2 years in a nursing home. I'm talking about someone that is 4 and 5 years in a nursing home and has built up a substantial amount of arrears. Those people, while they will not have to pay for the cost of the family farm or business going forward, where they have accrued the substantial amount of these particular arrears since the government decision in July of 2018, are still going to be forced to sell the family farm or part of the family farm, are still going to be forced to sell the family business because of the delay in drafting this legislation. Now, there are ample precedents there where legislation has been backdated to the date of the government decision. And all I'm asking is that families that found themselves in that situation in July of 2018, where they had already accrued the 3 years or accrued the 3 years between that date and now, would be able to avail of that relief rather than having a substantial body of debt to pay either to the nursing home or to the HSE as a result of it. And I think it's just wrong that they're caught in that particular position.
Okay.
Cahill, can I just respond briefly?
Please.
Thank you. Again, Deputy Naughten, I suppose going back to the whole premise of this new scheme, is contingent on the family successor being appointed, and the family successor cannot be appointed until the amendment is enacted and commenced. And can I also say one point? I'm sitting here today, a year since I was appointed to this particular role. It's a year today that I got the call from the Taoiseach, and it was one of my priorities to get this bill through. And we will have report stage as well before the summer recess. So, you know, there's a huge amount of work after being done in the last 6 months to get this over the line. But unfortunately, there will be no refunds for contributions to the cost of care for those who have already spent in excess of 3 years. The scheme currently, as it stands, costs 1.4 billion a year. The income from the scheme is 350 million. So it's costing the state in excess of $1 billion. And obviously with the amendment that will be removed at report stage in relation to the cap on the sale of the houses, there will also be a further costing to the state. So unfortunately, the reason why it was ruled out of order from the Bills Office is the cost. We all know people who are in nursing homes with 3, 4 and 5 years. Thankfully, it's not that many. 37% of all people who enter nursing homes are in nursing homes for 6 months. But there is a small minority of people who are there for a long time. But if they appoint a successor as soon as the bill is enacted, the time served will mean that the cap will be implemented almost immediately.
Just one final comment, Minister, and that is, Minister, in many cases, they have already appointed a successor. In many cases, they have legally appointed a successor. In many cases, that successor is operating the family farm or is operating the family business and now has a substantial debt hanging over them that is attached to this. So while they may not, under the terms of this legislation, meet the technical appointment of a successor, they have in reality, and many in legal terms, have already appointed a successor, and that should suffice for, as what you have admitted, is a very, very small number of families, a very, very small number of people. And it would be sad to see a farm being left unviable. It would be sad to see a business being left unviable and maybe jobs lost purely because we are not prepared to address this anomaly for a small number of people. And I will ask you to think long and hard about this between now and report stage.
Okay. Minister, do you want to reply to that? Deputy Jordan wants to come in as well.
I'll be very brief. You know, the Act as it stands now, like, in order to be a successor, you have to be officially appointed under the Act. That's the first point. The second point is anybody who is currently in a nursing home can avail of the NTPF scheme, the Fair Deal scheme as we know it, whether they're a farmer, they're a small business, or they just own their principal private residence. So that option is there. I do know it is challenging, but we have to work. We're trying to fix there the unintended consequence of the 2009 bill, where farm families and small businesses were penalised after the 3-year cap, and that's the whole premise of what I'm trying to do. So unfortunately, we'll have to agree to disagree, but I do know exactly where you're coming from on this.